step out so we can step out. Step out so you can go see Laura.
They're terrorists, and I'm telling the truth, and you're going to pay for that.
All right, maybe we will.
On April 8th, 2025, officers arrived at a private residence to execute an arrest warrant on a subject identified only as Laura. The warrant stemmed from prior criminal proceedings in which she had been released on bail. A judge had since moved to revoke that bail, generating the warrant officers carried today.
I want to talk to you about everything you've been calling in about.
There's nothing to talk about. You are directly involved. You're in extreme denial, and you're covering it up. You have no right to be on my property. You can't get me in my home. You can't get me on my motherfucking property.
Will you listen if I try to explain things right now?
Can't talk to you when you're doing that.
What do you need to? I'm telling the truth. You're terrorists.
Oh,
okay.
You've long harassed me and tried to silence me. I'm telling the truth.
I want to hear what you got to say.
We'd like to hear you.
This is my property. You have no right. I have every right. Go away.
We're not going away.
No, I'm not stepping out either.
We can't go away, Laura.
You're scumbag terrorists. I bet.
Laura. Laura.
I'm telling the truth.
Laura.
You're in extreme denial.
Well, I want to help you. What can I do to help you right now? What can I do? What can I do to help you right now?
I've already told you. I called all night.
Okay, I just called on this morning.
To my property, provide some kind of support and protection, and alert them. I've already told you.
Oh.
And you're in denial. You're covering it up, and so are they. You all need to die.
What am I covering up?
I'm being terrorized.
Okay.
The people terrorizing me are the Antichrist. You are a part of them.
I've never been a part of the Antichrist. Laura. Okay, I want to know what I can do to help you. Well, at this point, we can't do that.
Laura. We need you to come out. Laura.
We're not trying to silence you. You can say whatever you want and we'll listen.
All you do. All you do.
Hey, stop beeping for a minute. We have a warrant for you.
You're scumbags and you're harassing me.
Listen to me. We're not going away.
Oh well, you're terrorists.
Okay. Step out so we can step out. Step out so you can go see Laura. Windows, right? Come on out.
You're getting out of the car now.
Obviously.
Let's go.
Okay.
Open the door on your own. We've had enough of this.
You're terrorists.
That's right.
Careful, can I empty my shoes?
In a minute. What will you all do? Turn around, put your...
You're a terrorist, and I'm telling the truth, and you're going to pay for that.
All right, maybe we will.
No, you are.
You should have listened to us, though. We wouldn't have had to do that.
Come into custody with you? You're trying to silence me.
Open up.
This is all you do, is try to silence me. You're scumbag.
Not really.
You're in denial, extreme denial. Oh yeah, how many light bulbs? How many light bulbs is this, guys? You're exactly to it, scum. Real.
Hold on, don't turn around yet.
You can probably take these ones off here. Do you have anything in your pockets, Laura?
No.
All right. This could have been a lot easier.
You're scumbag terrorists. I've been calling the entire night. Yeah, it could have been a lot easier. You could have came out here when I asked you to.
Officers did last night.
No, I asked you to come here and sit in my property, and you refused to do so. I said, stay here until the federal authorities come, because that's what this needs. You're harassing people, you're extorting people, and you're terrorizing. You're terrorists. You're all gonna spend the rest of your fucking lives behind bars. I'm gonna see to it.
All right, relax.
All right, Laura, do you want to kick off your shoes and get this glass out?
Is it out
Out
of
of
there?
there? Okay. Nothing on you? No. Okay. Back to Chris's chair.
Yeah.
You want to tow?
We're gonna have to do something with it. So we can get it covered up. I don't know if we have any.
No, I think he.
Oh, you turned it off.
I didn't know if you wanted to tow it through the get failure to comply.
Yeah, we got that all bearing.
Yeah, might as well.
You want to bring it to start it? Or what?
No, we'll take it to whoever tows it. Tell them that we'll tell them that they need to put some plastic over the window. All right, I'm gonna get going with her.
All right.
Follow him back.
You want me to go with him and you take my truck?
Yeah, that'll work.
All right. You got keys for his truck?
I think it's running.
I was gonna say,
Well, it's still is it a fob or is it the?
dang it, just follow him and now he can jump in with me.
One night.
No, you get service. Can you give me a call?
Pretty soon. We just pulled in a garage.
I'll have a few minutes over here, so. So, do we have any
I'm
symptoms?
telling the truth, you're terrorists, and you need to turn yourselves in.
Okay.
You're gonna
I'll-
spend the rest of your fucking
Okay.
lives behind bars.
I'll work on that, but right
You're
now.
gonna spend. Look into my eyes. You're gonna
I-
spend the rest of your lives
Okay.
behind fucking bars.
Wonderful, wonderful. But right now,
Yeah, I
I'm just asking
bet.
a few
Well, yeah,
questions.
we'll add that to the remark. Wonderful.
Okay, thank you.
Yeah, we'll add that too.
So, do you have any medical issues we need to be worried?
Yourself,
Okay, thanks.
piece of.
Right. Are you thinking
You
about
get
hurting
that,
yourself in
huh?
any way?
Try to get that.
No, these people are terrorists, and I'm telling the truth. I've long tried to report that I'm being terrorized. I've been calling all night to 911. You didn't have the right to arrest me in my home, but you like to chase me around in the community because you're slime buckets who are in extreme denial.
We're just waiting on a female to patch it up.
Warrant, if you want.
That's
You take that. That's
the
be a good
place
start.
right now.
That'd be a good start.
Is it, who did the warrant?
I did.
No,
Italy.
Dempsey.
Dempsey? Okay. So it's Catherine.
Yeah, and he's going to be revoking her bail from the last. So. We need.
We'll take that one back if you want to make a copy.
Jeff, I can-
How's she been? You're terrorists, and I'm telling the truth.
Like that.
You're in extreme denial. Yes, the truth. Just like this, as a matter of fact. You're terrorists. I'm telling the truth, and you're in extreme denial, and you're going to spend the rest of your life behind bars, you little.
Ma'am, I need you to turn around so I can get the handcuffs off. She's gonna pass search you. Hand on the wall.
Do you have anything in your pockets? No, nothing. I don't believe me.
other hand on the wall.
Take your shoe off for me. Okay, let's go inside.
Have a seat there in that great chair. Okay, guys.
Okay.
Let's examine the constitutional framework.
Under the Fourth Amendment, a valid arrest warrant satisfies the constitutional requirement to seize a person even within their home. The Supreme Court established this principle in Payton versus New York in 1980, holding that officers may enter a residence to execute a felony arrest warrant if they have reason to believe the subject is present. Officers verbally announce the warrant's existence at approximately 3 minutes into the encounter, satisfying the knock and announce requirement affirmed in Wilson versus Arkansas in 1995. Within the first 60 seconds of footage, the subject's statements deviate significantly from reality. She references a conspiracy involving the Antichrist, accuses officers of bombing and terrorizing her, and repeats identical phrases verbatim across multiple exchanges. This pattern fixed delusional content, looped phrasing, resistance to all external correction is clinically consistent with a delusional disorder or acute psychotic episode. This distinction carries direct legal weight. Under Title II of the Americans with Disabilities Act 42 United States Code, Section 12132, public entities, including law enforcement agencies, may not discriminate against individuals with disabilities in the delivery of services. The Ninth Circuit addressed this directly in Sheehan versus City and County of San Francisco, holding that officers must consider reasonable accommodations before using force against a subject in mental health crisis when doing so does not pose undue risk. The standard is not perfection, it is reasonableness. But reasonableness requires recognizing the disability and adjusting tactics accordingly. The footage shows officers were on notice within the first minute. After more than 3 minutes of verbal negotiation failed, officers issued physical extraction commands. The subject initially refused, then complied once contact was initiated. Use of force here is governed by Graham versus Connor, decided by the Supreme Court in 1989. That decision established a 3-factor reasonableness test: the severity of the underlying offense, whether the subject posed an immediate threat, and whether she was actively resisting or attempting to flee. On all 3 factors, the calculus here supports minimal force only. The underlying offense was nonviolent. The subject posed no physical threat, and her resistance was verbal and passive, not active or combative. Officers responded accordingly. No weapons were drawn, no less lethal tools were deployed. The arrest was effected through soft, empty hand control, the lowest level of physical force on the use of force continuum above verbal commands. Post-arrest, a search incident to arrest was conducted within the bounds established. In Chimel versus California in 1969, limited to the subject's person and areas within her immediate control. Scope was not exceeded. A female officer arrived to conduct the secondary search consistent with departmental best practices and, in many jurisdictions, statutory requirements governing same-gender searches of female subjects. Throughout, the subject's verbal statements remain constitutionally protected. The First Amendment does not dissolve upon arrest. Under City of Houston versus Hill, decided in 1987, verbal challenges to law enforcement, including profanity and accusations, are protected speech. Officers correctly decline to treat the subject's words as additional criminal conduct. That restraint is legally significant and reflects sound constitutional understanding. The lead officer receives a B. His sustained de-escalation over 4 minutes using active listening language, maintaining non-threatening posture, and avoiding emotional reciprocation reflects crisis intervention training principles and produced the lowest risk arrest possible. The limiting factor is the absence of a mental health co-responder. Once delusional presentation was established, best practices required requesting a crisis team or behavioral health specialist if one was available. No such request appears in the footage. Departments that fail to deploy co-responder resources when indicators are present face increasing civil exposure under ADA Title II. In the precedent set in City of Canton versus Harris in 1989, the female officer receives a B+. She resolved a procedural gap, same-gender search compliance efficiently and without introducing new escalation. Her conduct within her defined role was without observable legal or tactical fault. The subject receives a C+. Her prolonged refusal to comply with a lawful warrant created the conditions for a physical arrest that a voluntary surrender would have avoided. That choice, whatever its clinical source, carries legal consequence. However, once physical contact began, she did not resist the handcuffing. She answered questions and cooperated with the search sequence. That ultimate compliance is legally and tactically relevant, and it prevented the encounter from escalating further. The department receives a B-. Officers followed proper warrant execution procedures, observed search protocols, and deployed female personnel appropriately. But warrant executions on individuals with documented mental health histories, evidenced here by repeated overnight 911 calls, and prior court involvement, represent precisely the scenario where co-responder programs exist to reduce risk to all parties. Departments without crisis co-responder capability, or that fail to deploy it, when behavioral indicators are present, carry legal and ethical exposure that a good outcome does not eliminate. 3 takeaways from this encounter. First, a warrant authorizes the arrest. It does not determine the method. Officers retain discretion in how they execute a warrant, and that discretion is constrained by the ADA when mental health indicators are present. Second, verbal resistance is not criminal resistance. The First Amendment applies at every stage of a law enforcement encounter. Treating protected speech as probable cause for additional charges exposes officers and departments to civil liability under Section 1983. Third, de-escalation is not a courtesy, it is a legal risk management tool. Encounters that end without force are encounters that generate no use of force complaints, no excessive force litigation, and no media scrutiny. Patient negotiation is also smart liability management. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.